POPI has been around for over 12 months now, but what do we practically need to do to comply? This is Stuff Employers Should Know.
Welcome to Stuff Employers Should Know, proudly brought to you by LabourNet, management's ultimate HR solution.
Hey, and welcome to the podcast. It's Yasu Yaslak at Ismail, and unfortunately, Mr. BGD isn't in studio today. He's inundated, as usual, probably at the CCMA. I should check up on that. Anyway, moving along to today's episode, discussing the practical side of POPI, and in studio with me, I have POPI expert Samantha Walker and our esteemed colleague Chanel Sprieman, and I've actually got her surname correctly this time. In a recent webinar, I called her Chanel Sprieman. I do apologize for that. So, ladies, thank you so much for joining us in studio, and obviously I'll let you show off your expertise on the topic.
Thank you so much, Yasa. As Yasa mentioned, thank you for joining us today. We're going to be discussing the practical sides of POPI, and I have Chanel with me in studio. The last time we were here, you had also just written an article, and back we are here again.
Yeah, no, I think that's the best. You really get a chance to obviously get into the work, and then you can have a good discussion about it. So yes, this is related to an article.
So the practical sides of POPI, I think that is probably one of the toughest lines to say, especially sitting here as data experts and knowing the complications around that. Now, what should we really be looking at with the practical sides of POPI?
The practical side of POPI pretty much relates to what it will look like in action. Being a new piece of legislation, we obviously really don't know what that looks like. As we undertake our compliance, we're also dealing with different organizations and what that looks like for different organizations. So when we're looking at what the practical side of POPI is, it's just really trying to break it down to see what it looks like live and, in action.
Hundreds. I think one of the biggest things I keep hearing, and you've alluded to it in your article, is a lot of organizations think that POPI is just a checklist. The act gives us a number of things to do, and then we have to do them. But how does the Act actually tell us what to do?
So the Act basically gives us guidelines. So it's what they call framework-based legislation. So there's no explicit direction to say that this is what you need to do to protect the information. They more just give you guidelines and kind of objectives that you need to put in place or aspire to, let's say.
So POPI is a very abstract piece of legislation. It's often mistaken where it just tells us what to do, but in essence, we need to find the best routes and methodology to implement it. But now, why is POPI so abstract?
Because it's very framework-based, a lot of guidelines, not a real explicit direction. But I think another thing that's led to, POPI being seen as being very abstract is because there was a lot of grace period with which to comply with. And I think it led to a lot of companies becoming relaxed. So yes, they don't really understand it. And then we go back to that checklist requirement that you mentioned. So with that grace period, I think they just became too relaxed. And I think also the information regulator, they don't have much of a presence within the space, so we don't actually have direction from them either. So in that way, it also just becomes a little bit abstract. But I think just generally, the data protection field is very dynamic. It's changing on a daily basis. And I think that just adds to, the confusion and, what's going on and how to really implement everything.
Yeah, I think that's one of our biggest challenges is that POPI is a new piece of legislation and it is evolving. We're getting guidance notes from the information regulator. I know I'm personally excited when this gets to litigation stage so we can have clarification on certain grey areas. Now, you've spoken a lot about a framework-based legislation. What exactly is a framework-based legislation?
So framework-based legislation would be legislation where there's no explicit direction in terms of what the specific entity or person should be undertaking and doing. So POPI is very framework-based. It starts with the 8 conditions. They just give you the 8 conditions. These are the principles that you want the data subjects and responsible parties to comply with. But they don't necessarily tell you how to go about doing that. So, for example, with the consent, we know that we have to get consent, but then we would then take it upon ourselves and say, okay, look, the best way to get it is via an agreement, for example. So we take that condition and then have to then interpret it for ourselves and then see what that looks like practically. That's pretty much what your framework-based legislation is.
Now, why do we really have this framework-based legislation? We've discussed what it is. There is no defined goals. At no point does POPI tell you need a password policy. We're obviously saying have a password policy because that will meet your seventh condition in terms of your security requirements. But really, what are the implications of having this framework-based legislation in POPI?
I think it definitely creates a lot of confusion because there's no explicit direction again. And I think with it being so new, you would definitely want hard and fast concrete rules, at least in the beginning, and then, practically see what they look like and see whether they work for you. So I think that's the main issue with the whole framework, that we don't know what to do with it. We don't know what compliance really looks like. And again, with the information regulator having been so silent, we actually also don't know what, they have in mind in terms of what audits could look like. I'm excited when you say that, you want to see what happens in court. I think they will also get a lot of guidance. The framework has really been, I think it's nice that it's holistic and it can be, interpreted for yourself. But then, it's two sides of a coin, where now the other side is like, okay, so I can interpret it for myself, but how and where? And so, yeah.
I think one of the biggest things I often get asked is why? Why did they build the legislation in such a way? Why couldn't they just tell us we've got to password protect emails or things like that? Would that not have been simpler? And the truth of the matter is no. But maybe you can take us through why framework-based legislation is really necessary here.
So I think when I was doing the work and doing the research, you just kind of accept that, okay, POPI is very framework-based legislation. But then when you actually look at the purpose of the act, it becomes clear that already from the onset, that was the intention of the legislature. And the reason it is framework-based is it allows for those objectives to be fulfilled. So obviously the purpose of POPI is to protect the right to privacy. So that's now a fundamental human right. So that is now open to interpretation. You can we understand that the right needs to be protected, but we can't necessarily dictate how. It looks different for different people, different organizations, different levels of privacy that would be required. And then if we look at the other purpose of POPI, which I think is one of the most important, that being the purpose of balancing the right to privacy now with other rights. So in that way already, you can't be too prescriptive when you're trying to balance the right to privacy and other rights, because you don't want to impede too much on business functions. So there's a balancing involved. So in that sense, it makes sense why we then have very framework-based legislation.
Yeah. I think specifically on that point and the balancing of the rights, I think that is fundamental to why POPI is like it is. We cannot have an absolute right to privacy. If we did that, companies wouldn't be able to have our personal information, municipalities wouldn't be able to have it. It would cause disasters in many, many areas. And that's exactly why it has to be this principle-based legislation, is because here's an objective to achieve, but how you achieve it in your environment, your industry, your organization, that's up to you. As long as we're getting to the end goals, POPI doesn't mind so much how we get there. Obviously, at LabourNet, we interpreted the POPI Act, but we've also looked at international legislation. That's what I did when I sat down and I built the product, because there's a lot of grey. And I've looked at how they've interpreted it, and I think there's only more coming. I really, really do.
In line with, as data protection is developing and technology is developing, it's just, we are still in the early stages,
No, I think there's a lot more that is going to change. Now, obviously, there's a lot of these sort of examples that we could give the listeners about what an objective or a principle-based legislation is. So I think the one that always pops up for me is the security safeguards, as I mentioned. At no point in the Act does it tell us what we must do. It just says we must try to prevent against loss or unauthorized access. And really, we have to interpret that. I'm not sure if you want to expand on that.
No, true. So it gives a lot of definitions in terms of what security safeguards have to look like. So the best way we've interpreted it to I guess, give effect to that is with policies, with internal policies, because you're going to have to look at what the Act says and then tailor that for your organization. It also helps to make sure that, your organization is growing or going at the rate that it can in terms of how policies are going to be implemented and created. The best is just the internal policies that have to fit the organization, but then ensure that, we are aligning with the Act. And then it also allows for that to fit in nicely into your business functions. So it doesn't impede too much on your business functions. And obviously policies, that's the only way that we can hold employees liable to anything. Once we expose them to a policy and they can comply with that policy, then they are in effect also complying with the act. And the organization then is also complying.
Yep, 100%. And I think what you've just mentioned now is a perfect example. At no point does POPI ask us to have policies. At no point. But in essence, POPI is asking us to change our behavior in relation to personal information. And we govern behavior in companies by policy. So that's how we then get to the policy route. But with all of these very abstract ideas, does POPI ever give us any concrete provisions that we've got to apply with?
There are definitely some concrete provisions that we do comply with or have to put in place. So the first thing I can always think of is registering an information officer. So that's very explicit. The Act says that each organization does need an information officer. And I think the information regulator has definitely echoed that with the way that they have been facilitating the registration. So in that way, we can at least see that's, what POPI looks like in action.
And I actually got confirmation this morning that the information regulator's portal is now open again on their website.
Finally.
We no longer have to register manually. We can actually go back and do it on that portal, which is very, very cool.
Finally, yeah. So that's now real practical. You can now see that in action. Also, so the idea of consent, just saying that you have to have the consent, is at least giving us some sort of a guideline. It's very explicit with regards to consent. I know at LabourNet we are advocates for consent. Because we very strictly stick to the definition that's within the Act. So at least we have that concrete provision to rely on. And now recently with the PIA manual as well, that's where we can also see POPI. Well, POPI would now be working in conjunction with PIA. The information regulator has now taken over the function of enforcing PIA. So at least with the PIA manual, we can see that that's now, live and in action. And then the reporting of security breaches. The Act is very explicit in terms of how security breaches should be dealt with, who should be notified. So at least we get some concrete direction from there.
100%. And I think we're going to see more and more on the reporting of security breaches. I know I personally woke up to 5 mails in my mailbox this morning.
Oh, jeez.
Of old clients of mine coming back asking for help with breaches. And the breaches are happening all over the place and from big organizations as well. So that's definitely one thing to keep in mind. If you do have a breach of personal information, you definitely have to report it. This is one space, as you've mentioned, that POPI is quite clear about it. I want to go back to consent. So yes, consent is a concrete provision that we need consent in certain instances. But the Act at no point tells you how to get consent. And I think that's another beautiful example of this is many of my clients will phone me and ask, no, but can't I just ask for consent on the phone? Of course you can. And once that person says, yes, I consent, you have their consent. Second issue crops up is when a year down the line, this person has reported you to the information regulator. How do you go about proving it? That's why it's our best practice at LabourNet really to follow that consent and have it in writing.
True.
So that we can actually use it later on. A lot of what we're doing now, I feel, is preparing for any investigations that do come. And I think that's so important.
And just on that idea of consent, when you're saying that, I'm thinking about how, yes, you have to have the consent, but you also need to record it. So with POPI, you also can't read it in isolation. You can't read that specific section and read it only as it is and only try to enforce that. So you have to, then it just adds again to that whole kind of, it's not just right there and then that's the only thing, Section 5 or whatever it is that you have to comply with. You have to read it now with other provisions as well and consider it holistically, let me say.
100%. You definitely have to consider it holistically. I think even with the policies, I think back to drafting many of our policies, there's probably 4 or 5 conditions at play at once in one policy because it just makes business sense to deal with it all in that policy. True. So I think another little part we can expand on here is we don't have to really follow the 8 conditions. We don't have to have a policy for each 8 condition. We will have a policy for a business function, like a backup policy that's informed by the conditions. And I think that's one thing everyone is really struggling with is what do you group together? What don't you group together? Do you have any advice on how they should group their policies, what they should look at?
Well, firstly, they should come to us and we can help. But I think when you're looking at putting your policies together, it is important that you definitely ensure that you're not impeding too much on your business functions. Because another thing is that you want to have the policy that can be sustainable. It must actually work for the organization. You don't want to have to keep changing it and see exceptions coming up. So my main thing would just be to ensure that it's definitely meeting your organization's needs, but then still being in line with the Act, which is, what we are here for. And policies can get updated as the information regulator also gives us more direction. These things can be updated. But yeah, the best is just that balancing again. Let's ensure that your business functions are still there, and you're giving effect to the Act.
I think, 100%. The only thing I could potentially add to that is I think we should be looking at two groups. Yeah, I know we've defined it here at LabourNet. We have our IT policies and our organizational policies. But I think it's important to explore, because when protecting personal information, often we are very, very focused on the IT side. We cannot forget our files in hard copy and how we protect that there.
True. Because we have a range of organizations, small organizations, big organizations, somewhere it's just one person dealing with everything. So you definitely have to just basically track your information flow and really see how it's from when you get it, hard copy, soft copy, also just disposing of the information. Even if it's in soft copy, that has to happen.
100%.
In the right way,
yeah, there's actually all sorts of companies out there nowadays that will destroy your data for you, come and wipe hard drives, etc., and give you certificates. So even if you don't have the skills in-house, there is so much available for you to use currently in the market. I would just make sure that the suppliers you are using are also POPI compliant.
Yes, definitely, yeah.
So we've chatted about the various areas now on the abstract versus framework-based application and really why it's beneficial. Maybe, do you want to give us a summary? What should everyone be looking out for? Yeah,
look, POPI is definitely in its infancy stage. I'm glad that the information regulator seems to be coming to the party. But I would say just, make sure that you're managing, your compliance. You're never going to reach an end point. But make sure that you are managing it. You're keeping up to date with what the new regulations and all of that are. But in general, in terms of what it practically looks like, I think we're just at the beginning. It's our new normal. So we'll just have to adopt. And then, as things go on, we can start to see what it looks like practically. And then when it's, in action.
100%. I think the best bit of advice we can give is this is a continuous process. You are not going to tick a couple of check boxes on a tick list and be done. You will forever be working on your data protection and your POPI compliance. And I think once everyone understands that, it's going to go a lot easier because it is this continuous exercise that we must do.
Definitely.
Well, that sums up a lot of policy implementation that you guys have spoken about. I'm very confused, so I'm definitely going to have a little session with the two of you to understand this a little bit further. But thank you so much, ladies, for obviously your time and giving us insight on POPI and how to implement those policies and what obviously businesses need to be cognizant of to ensure compliance throughout their workforce.
Thank you so much for having us. Always a pleasure.
Yes.
And that sums up today's episode of Stuff Employers Should Know. Huge thanks to the POPI team for coming out here and taking time out of their hectic schedules. If you need assistance from their side regarding the implementation of POPI within your business or a better understanding of the practical side of POPI, pop them an email at popi@labornet.com. That is a lot of popping going down. I will leave their email down in the description below. Or if you want to get in touch with us, pop us an email at sesk@labornet.com. Let us know what you thought of today's episode. Let us know what you thought about previous episodes. Or let us know what sort of topics you want us to discuss in future episodes. From myself, Like it Ismail. Cheers and stay safe.
Stuff Employers Should Know was proudly brought to you by LabourNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.